It's one of the biggest gospel music festivals on the East Coast, and this year it features the biggest lineup ever. The Virginia Beach Gospel Music Festival, October 8th through 10 at the Sandler Center for the Performing Arts, with Guy Penrod, the Booth Brothers, the Triumphant Quartet, Mark Lowry, Daly and Vincent, Brian Free and Assurance, the Martins, Jeff and Sherry Easter, the Hoppers, the Irwins, comedian Tim Lovelace, the Penny Loafers, and more. The Virginia Beach Gospel Music Festival, October 8th through the 10th at the Sandler Center for the Performing Arts. Tickets are available now. By phone at 877-392-9710. That's 877-392-9710. Online at imcconcerts.com. imcconcerts.com. It's a tsunami of gospel music hitting the East Coast. The Virginia Beach Gospel Music Festival. It's 3 days and 5 big sessions at the Sandler Center for the Performing Arts. For more information, go to virginiabeachgospelmusicfest.com.
And good afternoon. I'm George Yates, and this is Justice for All. And thank you for joining us. We'll be here for the next hour with another one of my shows where we each week I interview a world-class legal expert, and we try to look at the issues of the day through their eyes, and hopefully we educate our listeners, and maybe we make a little difference in the world of our justice system in the United States and in the world, because sometimes we have lawyers and barristers from around the world talking about the justice system in general and in particular. And today's no different. We have a really great guest today. I'm very proud to have Gerry Morris with us. That's E.G. Morris. He's a top trial attorney from Austin, Texas. Has been practicing criminal defense since 1977. That's going back a long way. And Mr. Morris is a board-certified criminal defense attorney in Texas, and is now the current president of the National Association of Criminal Defense Lawyers, which is the preeminent organization really representing criminal defense lawyers and the actual criminal defense bar in the country today. The NACDL is the preeminent organization. Really, I'm a member of it, and it's designed to ensure justice and due process for persons charged with a crime or wrongdoing. And Mr. Morris is the current president of that organization. And it's recently come out with a report, the NACDL, that is. And you can always, if you're interested, you can always go to their website at nacdl.org. And Gerry will tell us a little bit about that organization in a minute. He's recently co-authored or helped co-author a report on indigent defense in America. That's kind of his main focus right now, is the sorry state of the criminal justice system these days, with folks who cannot afford attorney, cannot afford private counsel, and so they end up having a court-appointed lawyer to represent them. And it's the sad state of public defender in this country is that so often public defenders are overworked and underpaid, have too high a caseload to really do the kind of job that needs to be done to defend the folks who are too poor to represent themselves or too poor to pay lawyers to represent them. And so that's going to be the focus of our show today, among other things. So I'd like to welcome to the show for the next hour, E.G. Gerry Morris from Texas. How are you, Gerry?
Good. How are you, George?
Thanks
for having me.
Yeah, great. And thank you so much. You're the president of the NACDL. You have been, I see, how long does a presidency of the NACDL last?
A year. It's a year term.
Okay, and I saw that you were, so you've been the president. This is your first, did you just become president, or has been a while?
July 25th.
All right, great. Well, listen, first of all, before we get into the NACDL stuff, I think I'm kind of want to introduce you to our listeners. What made you, Gerry Morris, a young man, you've been doing this 38 years now, and so when you were a young man, you decided to become a criminal defense lawyer. What drew you to this type of, to the profession of law, and what made you gravitate towards the criminal defense area?
It's a calling, I think. I don't think I sat down and said, now, here are my options. I could go into medicine. I could go into accounting. Where's the most opportunity? It was somehow I was called to this profession, and I'm not sure why that is. in my remarks when I was sworn in, I said it may be something in my DNA, and if you're examining the genome, you might look next to the genes that cause mental illness because it may be somewhat related. But I went to law school to become a criminal defense lawyer. I never had any other career in mind.
Isn't that something? You know, I interviewed Cheney Mason. He's a veteran. I don't know if you know Cheney from Florida.
Yeah, real well.
And wow, what a character he is. And he says pretty much the same thing. It was just a calling that he'd had since he was very young. So that's great. Well, listen, so you are now the president of the NACDL. What is the NACDL and what is the role of the president?
Well, NACDL is, as you said in your opening remarks, the preeminent criminal defense organization. We have about 9,200 direct members, and we have hundreds of affiliate organizations. For instance, the Texas Criminal Defense Lawyers Association, or probably the one your local organization is an affiliate. And counting the membership of the affiliates, we represent about 40,000 criminal defense lawyers across the country. And we have, you could break our role down into, I suppose, two categories. One is member service, and by that I mean providing members with the tools to be the best lawyers they can be, and to assist them with their cases. CLE, continuing legal education, which I think is second to none. We provide assistance on individual cases through our resource council. On capital cases, we have a Bring Your Own Case program that we run in various parts of the country. And then the second category would be policy. I think sometimes this is overlooked or not. The rank and file practitioner doesn't perhaps appreciate what we do in this regard. When you walk into the courtroom, you've got an evidence book in your briefcase. You've got a statute book. You are going to cite cases that have been decided over the years. Somebody from the defense bar was at the table when those rules were made. Somebody from the defense bar was arguing those cases. We have a very active amicus committee that I think filed 19, if I recall the number correctly, 19 briefs last year in the Supreme Court. We're the second most cited organization in Supreme Court opinions as far as amicus organizations. The rulemaking, the legislation is ongoing. Every day, every working day, there's some meeting somewhere where some rule is under discussion or some law is under discussion. We're the defense bar's representative at the table when those rules and laws are being made and in the courts.
Well, now you've been on the board of the NACDL now for close to 15 years. Do you devote quite a bit of your time then to this organization and what it does for the rest of the criminal defense bar?
Yes, I do, and of course that's really accelerated this year. Part of my role as president is to travel around to the meetings that we have, of course, and all the seminars we have, but also I'm invited frequently to meetings of our state affiliates. This year I've been to, of course, the Texas affiliate annual meeting, the Florida annual meeting, Tennessee. I'm about to go to the Illinois meeting next month. In November. I went to the Arkansas Association of Criminal Defense Lawyers annual meeting, and that's one of the things I really enjoy about this position is going around the country and meeting criminal defense lawyers and hearing about their practices and about the issues that they're facing, and they're generally pretty homogeneous in their concerns. Everybody's facing the same thing everywhere.
Yeah. So what's the latest? What's going on with the NACDL these days? What are you working on? I mentioned in my opening remarks that there's a new report out. And I know that that's kind of something that you've been working on, this whole idea of indigent defense, in other words, the poor and having representation. I know you've got some other things that are on your mind. So this is your show today, Gerry. What do you want to tell us about what you're working on these days? What's cutting edge as far as criminal defense in your mind these days?
Well, when you first realize that you're going to be president of the organization, or it looks like you will be. That's actually a few years before you become president. You start thinking about what you're going to do, what you're going to focus on, and there are just so many issues that need addressing in the criminal justice system, and they change in priority depending on current events to some extent. So what the president ultimately has to do is pick just a few to prioritize, and then sort of be a hockey goalie on the others, catch what comes up. And the three that I singled out are indigent defense reform, which we're going to talk a lot about, the challenges facing the defense bar in litigation of cases involving electronic surveillance or mass data collection, and then the forensic science issues, admissibility of forensic science evidence in the courts.
So let's start with indigent defense. I know you've got what's that report for those of us that are listening to it? We can go to the NACDL and pull up that new report.
Yeah, the name of the report is Federal Indigent Defense 2015, The Independence Imperative. And this is not something, you mentioned I co-authored it. Actually, this is something that was developed over 18 months in the span of now 3 presidencies. And it was authored by a task force that worked on it during that entire time. There was about 130 interviews with various stakeholders in the criminal justice system, judges, members of the judicial staff, defense lawyers, members or staff of the administrative offices of the federal judiciary. And what brought this about is, to give you a little bit of background about the federal defender system, there are basically two broad categories of lawyers that represent indigents in federal court. One category would be people that lawyers that work for federal public defender's offices, and there are actually 2 varieties of those, but that's not that important today to distinguish those. And then there are lawyers who are in private practice that in some manner receive court appointments. And that system's been going on since the 60s. But when the system was established, those that established it made it very clear that it needed to be studied periodically to determine whether it was set up right and working correctly. But it hasn't been studied very much. There was a report about 20 years ago called the Prado Report that did an extensive study and recommended that the federal public defender function, and when I say federal public defender, I mean both the private attorney representation and the federal defender offices, should be moved out from the agency where it now resides, or the branch of government where it now resides, that being the federal judiciary, and put in an independent agency. In other words, it should be independent of the judiciary. That recommendation was not followed. It's still under the judiciary.
Which means that the judges are the ones who select the lawyer that's going to handle the case or gets assigned to a particular case?
It depends on the jurisdiction and also on who the lawyer is. If the lawyer works for a public defender's office, the judge doesn't have that direct authority to decide which public defender gets which case. It's more removed. The public defender, the head public defender, is chosen by the appeals circuit court in that jurisdiction, and his or her salary is determined by the federal appeals court. The budget, to some extent, or to a large extent, is controlled by the judiciary. Like, for instance, during sequestration, when budgets were cut across the board, the circuits basically dictated to the federal public defenders what their budget was going to be and how much of that was going to be allocated to staffing. And so there were staff cutbacks. Now, as far as with private attorneys that represent defendants, in many cases the judge does have either direct or sort of, once removed, direct control over who gets appointed. There are what we call CJA panels in a lot of jurisdictions, Criminal Justice Act panels of private lawyers, that lawyers sign up for the panel. There's depending on the jurisdiction, various criteria for getting on the panel. And then it's also not uniform as to how the cases are apportioned among the members on the panel. And then there are other jurisdictions, like the one that I primarily practice in, that doesn't have a CJA panel, as a group of volunteer lawyers, and the judges decide which lawyers get which cases. Sometimes those appointments are made based upon the difficulty of the case. They'll try to match, in their mind, the right lawyer with the right case. Sometimes it's done on a rotating basis. It's the next name up.
So, at the end of the day, did you make some recommendations then with this study, or were there problems with the indigent system that the NACDL made recommendations?
Yes, we did. We have basically 7 recommendations that we call the 7 fundamentals of a robust federal indigent defense system. Yeah, I just want to touch on a couple of them in the interest of time. The ones that may be the most controversial,
right,
and
go.
I think maybe the most important. One would be to remove the defense function from the judiciary. We think that there's just an inherent conflict when judges have control over the funding for federal public defenders, the appointment of private defenders, the payment of private defenders. The private defenders submit vouchers to the judges to get paid for their services. The judges have the authority to pay what's submitted or to cut the voucher. They don't have to give an explanation of why they cut it. And I'm not going to say certainly that by and large judges are unfair in that respect, but there's always that feeling if you're an appointed counsel in a federal case, that if you've been particularly aggressive, if you and the judge have disagreed on some defense tactic or some request for funding, for instance, on an expert, that somehow that's going to show up in the ultimate payment that you receive from the judge. And by the way, this is not something that we just came up with. The American Bar Association years ago came out with their 10 principles of robust in a defense system, and one of their principles was independence from the judiciary. This is a well-recognized principle.
Yeah, because is there any evidence, or do you have any anecdotal evidence that that let's say somebody was favored over someone else, or you say there's an inherent conflict, and perhaps there is, but is there actual evidence to support that? I would assume that there was some data on that.
Some of the people that were interviewed by the task force had anecdotal evidence, and they told them about it on the condition of anonymity. So,
it's because you're kind of biting the hand that feeds you. You're going out and saying that a judge, might have favored one lawyer over another, or maybe gave more compensation to this lawyer than that one because he maybe went along to. Is that the idea, that maybe a lawyer will go along to get along and get paid more, or maybe not be as aggressive in the case, or not ask for that extra expert that he should have asked for or could have asked for, and so then maybe gets another assignment, or maybe gets paid more for the case? Is that the fear?
That's the fear, and I think. I don't know how many federal judges I've appeared before in my career, but certainly nowhere near all of them, so I can't paint with a broad brush, but I've seen things happen in federal court where I felt like the wrong lawyer was appointed for a case, clearly. There was a case, and I don't want to mention the name of the case because I don't want to single anybody out, but there was one in particular where a lawyer was appointed to the case that did something that legally was wrong in the case. It wasn't intuitive really that it would have been wrong. It was just contrary to a case that had been decided recently. I ended up at the request of some people taking the case pro bono, and we got it straightened out. But that lawyer was a very good lawyer in his field, but he had very little experience in criminal defense. and it was a relatively obscure issue that he had run afoul of. And I think that that's an instance where I'm not sure exactly why that lawyer was appointed, but there needed to be more control in that circumstance over the qualifications for the lawyers that were eligible to receive those appointments. Some requirements of periodic training to make sure they were up on the latest case law.
Well, now, and I know we're talking about 7 points, and I know you want to get to them, and we got about just a few more minutes before our break, but when you make these recommendations, and you're saying that the ABA has also recommended this some years ago, and when you make these recommendations, you're asking it's pretty hard to ask judges to give up authority. That just doesn't happen in this country, does it? I mean, right now the system is set up for judges to do this. It seems like every day we read something. I just read an article yesterday about how much power the Supreme Court of the United States has over which cases to select and which cases to not select, and when are we going to start taking away that power so that they have no, so what are the chances, before we move on to the next 6 points, but what are the chances of these this agenda being enacted when you're actually asking a judge to give up authority?
Well, the timing of our report may be fortuitous in that respect. Justice Roberts recently appointed a committee or commission of judges and some other stakeholders to study the indigent defense system. We have submitted our report to that committee, and we've received feedback that they're interested in our continuing input on the matter.
All right.
And so if we can influence the outcome of that committee with our work, then we will have accomplished what we set out to accomplish.
All right. Well, then what are the other main points that you wanted to get to then? The independence of the selection of lawyers as well as compensation. What are the other points that the report covers?
Well, the other one, if independence is 1A is funding. There simply needs to be adequate funding for the defense function for it to do a job on par with the job that the prosecutors do.
Right.
To have the resources. Exactly. And when I raise that point, usually that somebody says, well, you're talking about just lawyers making more money. It's not just lawyers making more money. It's lawyers having the resources in terms of expert witnesses and investigators to combat what is just the ever-increasing sophistication of federal criminal prosecutions. I don't know when the last time I've seen a federal trial or been in a federal trial was that there wasn't some expert on something.
Well, not too many federal trials anymore. 98% of cases plead out now. I mean, you can't. The way the system is set up, there's a trial penalty, isn't there, Gerry?
There is, and that's a discussion for another hour, I would think.
Right, exactly. Which is we've talked about that a number of times on this show. So more money for the lawyers, so the lawyer can spend a little, maybe make a little more himself, but really more resources for investigators, for experts, and that kind of thing. So, because I mean, when you're up against the federal government, they've just got you got the FBI, the DEA, the Homeland Security. You got local law enforcement. It's amazing the amount of firepower the government can bring to a case, and here you are, if it's some private attorney who's been appointed to the case, and meanwhile you've got a bit of another law practice that you have to run. So
and that's the issue with the funding and increasing the payment to lawyers is not that lawyers want to get in a higher tax bracket. It's that you have to be paid enough that you can allocate the time to the case that's required. There's only so many hours in a day, and electric bill keeps going up, and salaries keep going up. Your compensation has to go up to stay in pace with that. Right.
Well, listen, we're going to go to a short break here. If you've just joined us, show's moving along quickly, so we got a couple other topics we still want to get to, your ideas about forensics reform as well as electronic surveillance. So we'll be back for the next 30 minutes with Gerry Morris, the president of the NACDL, the National Association of Criminal Defense Lawyers. This is Justice for All. We'll be right back.
The place for authentic Indian food is the India Palace. They feature authentic Indian cuisine, have a party hall, and do catering and banquets. Open daily for lunch and dinner, they showcase an excellent lunch buffet at their Chesapeake and Virginia Beach locations. Visit their 2 locations at 1437...
With SRN News, I'm Ron DeRockstra. Pope Francis resting at a suburban seminary in Philadelphia. Later today, he'll give a speech on religious freedom and immigration in front of Independence Hall, then make an appearance at the World Meeting of Families Festival. Cuban President Raul Castro says the reestablishment of diplomatic relations between his country and the U.S. constitutes major progress, but he says the U.S. economic blockade against Cuba is the main obstacle to his country's development. UN humanitarian chief says appeals for help have grown by more than 600% in the past decade and now reached about $20 billion. Stephen O'Brien says most humanitarian aid this year will go to just 5 protracted emergencies: Syria, Iraq, South Sudan, Central African Republic, and Congo. And volunteers were attacked after helping prepare a new refugee shelter near the German eastern state of Saxony. No injuries were reported. This is SRN News.
Leaky faucet, refinishing all
Attention!
countertops. Hey,
Renew
Gerry
is
Sullivan
currently
here.
seeking
Perhaps you're
participants who are
restaying
dealing with
after a
stress
living
and
room,
unhappiness.
whatever it is.
If you
Let
are
me
experiencing
help.
one or
I'm
more
gonna
of the
give you
following
tips you
symptoms,
need
you are
to
eligible
finish
to
those
participate in the
pesky
trial
projects
and
you've been
receive a
putting
free
off.
2-week
If you're
supply of the
restaying,
mood
got a
boosting
tip for that.
supplement.
Get the paint off the hardwood floors. Got a tip for that too. I'm here to make sure that $5 repair doesn't turn into a $500 repair. Join me right here every weekend.
Saturdays at noon, Sundays at 9 a.m. on AM 1650 WHKT, The Answer.
The place for authentic Indian food is the India Palace. They feature authentic Indian cuisine, have a party hall, and do catering and banquets. Open daily for lunch and dinner, they showcase an excellent lunch buffet at their Chesapeake and Virginia Beach locations. Visit their 2 locations at 1437 Sam's Drive in Chesapeake off of Battlefield Boulevard and 5600 Virginia Beach Boulevard in Virginia Beach, and online at IndiaPalaceVB.com. On Facebook, look for India Palace Virginia Beach and India Palace Bar and Grill. Dine at the India Palace today. Hi, this is Greg Picaveras inviting you to join me for Sports Scene live each Wednesday from noon to 1 right here on News Talk 1650 and TuneIn.com by typing WHKT in the search box. Excellent guests and interaction at Greg Bick on Twitter, all powered by HamptonRoadsOnlineMall.com. Sports Scene each Wednesday from noon to 1 right here on News Talk 1650.
Are you prepared to defend yourself and your family against any threat? Veteran-owned and operated One Shot Trading Post is ready to make sure that you are. Continuing training and classes on defense, survival, and weapons. Full gunsmithing services, special orders and financing available with military discounts. $15 transfers, and One Shot Trading Post is always looking to buy, sell, or trade. Located at 4366 Holland Road at South Plaza Trail, make sure that you're ready for anything at One Shot Trading Post, 463-5893, OneShotTradingPost.com.
Mark Levin here, reminding you to tune in every evening, 6 to 9 p.m. for some no-holds-barred opinions and discussion of what's happening. If you don't have an opinion, don't worry. I'll give you one. So you have no excuses not to join the Mark Levin Show, Monday through Friday, 6 to 9 p.m. on your source for conservative talk radio, AM 1650 WHKT. Now, we have some real problems in our country, and they won't get any better by themselves. Be a part of the solution. Mark Levin, weekdays 6 to 9 on K-Talk 1650.
Mi Hogar is your restaurant for the finest Mexican cuisine in Hampton Roads. At Mi Hogar, everything is prepared fresh in a casual atmosphere. Enjoy traditional favorites such as quesadillas, tacos, burritos, and fajitas, as well as refreshing beverages. Mi Hogar has 2 locations, 4201 Granby Street in Norfolk and 801 North Battlefield Boulevard in Chesapeake. Call ahead at 640-7705. At Mi Hogar, there is something for everyone.
Okay, we're back. I'm George Yates. This is Justice for All. We're here for the next 30 minutes with Gerry Morris, who's the president of the National Association of Criminal Defense Lawyers. And Gerry is a top criminal defense lawyer from Austin, Texas, and he's here today. I'd like to thank him for being on the show. And if you if you just joined us and you'd like to catch the entire show or the entire interview with Gerry Morris, you can go to my website at www.ghylaw.com. That's ghylaw.com. And listen to this interview in its entirety. We also have a YouTube channel, Justice for All, with George Yates. And anyway, so we've been talking with Mr. Morris here about indigent defense, and there's some other items that you'd like to talk about. Forensics reform, and anybody that listens, everybody watches, one of the NCIS shows. Everybody knows about forensic evidence, don't they, Gerry? And then the other you wanted to talk about was electronic surveillance, and we got 30 minutes, so I know you're passionate about both these subjects. We could probably talk a couple of hours, but what is it? What are the main points about getting reform in the area of forensics in America's courtrooms?
Well, a little bit of background on this. I think one of the most profound sea changes in criminal justice in a number of years was caused by the Innocence Project movement. Before DNA exonerations, there was this air of, I won't say infallibility, but certainly air of legitimacy of the jury verdict, that if the jury found you guilty, then it must be so. And there were also other, what we now know as myths of infallibility, such as eyewitness identification and how reliable it is. Now, looking at the statistics on the 330 to 340 exonerations that have happened over the country, we find that 70% of them, some of the wrongful convictions in some respect, were the result of faulty eyewitness identifications, and about 47% of them were somehow were occasioned by the improper application of forensic science in the courtroom. And I would actually lump those two together, because I think that the eyewitness identification, or at least the notion of the infallibility of it, needs to be attacked by competent forensic science. And but anyway, on the issue of the 47% of the more or less hard science testimony in the courtroom, that it was improper for a variety of reasons. It may be that the underlying forensic science, or so-called science, was invalid. It was just junk science. It may be that it was improperly applied in a particular case, that it was put forth as doing something that it just simply cannot do. Or it could be that the person that testified about it or that conducted the test wasn't qualified to do either. Or perhaps the person that testified is in the situation we're dealing with now with hair microscopy, may have basically stretched the meaning of the findings of the science, and in effect made it seem more certain than it really was, that it was, or enhanced the probability of it, I guess you would say, with the testimony. So, continuing with the history, in 2009, the National Academy of Science released a comprehensive report on the state of forensic science in the country. Their recommendation was that the system be overhauled, that that the admissibility of forensic science basically be much tighter, that the rules for admissibility be much tighter, that the science be validated before it could be admitted, that there be accreditation of some sort for those that testified about it. Nothing really happened for a few years on that recommendation until 2013, when the Justice Department set up the National Commission on Forensic Science, and their goal was to strengthen the practice and improve the reliability of forensic sciences. And forensic science means science in the courtroom. They have partnered with the National Institute of Science and Technology, and specifically the organization of scientific area committees within that organization. And what all that alphabet soup boils down to is that in NIST and OSAC and what have you, is there's now some government agencies that are working on coming up with standards for validation of science, determining which sciences are valid, which aren't, determining the application of the sciences, and establishing some sort of criteria for accreditation. At this point, all the accreditation would be voluntary. Our position is we'd like to see it mandatory. We would like to see both the accreditation and the validation mandatory before the science comes in. We have members that are members of the various committees within these organizations that are providing our input on what we think the standards should be. There's also a facet of this process that deals with the discovery that defense counsel would get during the trial or prior to trial, in preparation for trial. We want to see the discovery expanded, where we get broader access to the process by which the scientific tests were conducted, greater opportunity to review those tests and basically present a more vigorous defense to the scientific testimony. Some of the areas that we're talking about, and these are just a few, just to give your listeners an idea. Bite mark evidence. There's never been any scientific validation of bite mark evidence. There's never been any test to see if the test can be to determine if bite marks came from a particular person can be replicated from one laboratory to another. No statistical analysis as to the reliability of it. It's basically shooting from the hip.
That's junk science for sure. Bite mark evidence is junk science.
Yeah. And one that I've had some dealing with is basically arson evidence. There are a lot of there's been a lot of publicity about some of the false assumptions in arson investigations. Several of the national news magazines have run stories on that, and actually a case that I was involved with several years ago, Dateline did an hour on it. The case that I was involved with involved an expert that testified. His qualifications for being an expert were he had been a chief of a volunteer fire department for a number of years and had been to a lot of fires, and he testified to some things that were just that violated the laws of physics, basically. Talked about the behavior of fires and the path that flames would follow and smoke, and it just didn't square. And the lawyer that tried the case didn't obtain expert assistance to counter that, and that was part of the challenge post judgment, was to point out that science was wrong. But there are just many instances where arson investigations have gone down the wrong path.
First of all, I'm going to put a little plug in for my show here, because we have had guests from the Innocence Project. You've mentioned in just one brief moment here, you've mentioned so many topics that we've covered. We've had folks from the Innocence Project. We've had experts on this whole eyewitness identification. We've got a UVA professor that's written a book on it. We've had many folks, talking about the fact that these jury verdicts are not infallible. We've had people on our show that were exonerated by DNA evidence that did time on death row, and of course, who were convicted by jury. So everything that you've just been talking about here have been really subjects on our show. Anybody wants to go to the website, ghylaw.com, you can see all these shows, both from the Innocence Project. But these things that you're talking about, and I had an expert witness on the show the other day that wrote a book about this. Aren't judges supposed to be the gatekeeper for this? And and is this but some judges will let this junk science in, some won't. I had a case years ago actually with bite mark evidence that ultimately the government chose not to try to introduce it because we kind of showed that it was junk. But what are you trying to say with this new, let's say, accreditation standard, that it's going to take more, what it's going to do, maybe give more of a standard for the judge to follow in allowing this evidence in the first place?
It'll give some guidance. If it's voluntary, then it's not going to be determinative of the admissibility of it. And again, that's why we'd like to see it mandatory. But
right. Yeah. Okay.
It certainly gives the defense attorney then the valid cross-examination of, there are people that do what you do that are accredited. They have to go through some sort of training, some sort of review to determine if they know what they're doing. You haven't been through that, have you?
Yeah, I mean, how in the world did this chief of police or whoever this volunteer fireman, how in the world did he get qualified? He got qualified and expert because he'd been to a lot of fires. So, yeah. But it turned out that he really wasn't an expert on the topic.
That's correct. And when you read a transcript on a trial like that, you'll see the prosecutor leading the expert farther and farther out into the weeds, away from the things that he does know, and then sort of guessing to add strength to the case. And
right.
that's exactly what happened in that case.
And just so we can, I don't want to. Right now, we've only got an hour. We just got a few minutes left. So, where can people get more information on this? Is it on this standardization? Is this going to be a report coming out by NACDL? Where can we get more information on that?
Well, on this, the commission that I talked about, the formal name of it is the National Commission on Forensic Science.
Okay,
it was actually established by the Department of Justice. The Department of Justice in the last few years has really been aggressive on some issues, and that traditionally would be defense issues. They've been very aggressive, for instance, in indigent defense reform that we talked about. They've intervened in some cases and taken the side of the litigants claiming that the system was inadequate.
So this is also a work in progress that we're trying to get to a more uniform standard on some of these sciences and the expert testimony that's going to be admitted on them. So
yes.
Well, then I know then you had one other topic you wanted to talk about. So we've got just a few more minutes in the show, and that's going to be on this electronic surveillance and the collection of the mass data collection, in which we've I guess Edward Snowden, or what is this? Is this kind of where we're talking about this? The fact that everybody's being being spied on by the government. Where are we headed with that, Gerry?
Well, where we're headed with that is the technology is just far beyond belief at this point of what can be done. Regardless of how you feel about Edward Snowden, he certainly revealed a lot to us about what the government does. And I was reading an article the other day again about the Bush administration wanting to expand mass data collection under the Patriot Act, going to Attorney General Ashcroft when he was in the hospital to try to get him to sign off on something expanding it, and him refusing to do so.
Right, that's a famous, probably the most famous thing John Ashcroft ever did while he's in the hospital bed, refused to sign it.
Yeah, so the technology is just phenomenal now. I was instrumental in putting together a symposium last April in Washington, D.C. to bring together industry leaders in technology industry, attorneys that, for instance, an attorney with the Electronic Freedom Foundation that's very much involved in monitoring the use of electronic surveillance and mass data collection, just to name a few, some policymakers to hold a panel discussion on this. And this, by the way, if you Google Washington, D.C. Symposium, Fourth Amendment, electronic surveillance, I think those keywords will probably get you to the online audio-video recording of that on C-SPAN.
Well, we're really seeing some pushback, aren't there? I mean, we've got enough people out there that are upset about this that are we going to see some pushback from judges on this technology for privacy purposes? Where are we headed with that?
Yeah, I think we're already seeing that. We're seeing some judges decide that the Fourth Amendment does cover certain things like stored electronic communication that under traditional Fourth Amendment law or previous Fourth Amendment law was thought to be somehow exempt from Fourth Amendment because of third-party doctrine or something like that. We're seeing, I think, in the judiciary much more consciousness, I guess, of what the privacy interests involved. And Jones versus U.S., the GPS case 2 or 3 years ago in the Supreme Court,
right,
I think was really an about-face by the Supreme Court, determining there was an expectation of privacy in a person's movements, and the lines are a little fuzzy on where that expectation of privacy reaches. but the concurring opinions, it was agreed that 28 days of following somebody around electronically was too much, and there was a Fourth Amendment issue there. What we're doing is, one thing that really was driven home to me from sitting through the symposium that I talked about was how little I know about the technology. I thought I was pretty technologically savvy. I listened to those presenters, and I realized, number one, I don't know what's out there now, and number two, it's moving so fast. If I did know what's out there now, I wouldn't know what was out there tomorrow.
Give us some examples of some things that you didn't know that it's capable, that technology is capable of doing.
Well, for instance, the extent of the mass data collection, the involvement of the telecommunication companies in assisting the government in collecting this data, the pressure that the government puts on the telecommunication companies to assist them, the use of...
How do they do that? Do they threaten to take away their licenses, or what's the pressure they can put on these companies to cooperate?
It's to some extent it's not really threatening to take away their license per se. It's the regulatory framework may change. I would invite your listeners to go to C-SPAN, look up that symposium, and listen to our luncheon speaker, who's a former CEO of Quest Communications. His name escapes me right now, but he talked extensively about his experience with that.
The pressure that was put on his company by the government to cooperate and give data?
Yeah, and his refusal to do so, he was ultimately prosecuted for something else for insider trading under a very unique theory.
Oh, my God.
And was convicted. It was reversed by a panel and upheld en banc, but I'd invite the listeners to go, rather than me try to summarize it and be inaccurate, because it's fairly detailed. Listen to his presentation.
And you can just Google electronic surveillance symposium, and you can it'll pull up.
Yeah, electronic. Probably throw in NACDL as well. Electronic surveillance symposium, NACDL.
All right.
And again, the links are on C-SPAN. They covered it.
Okay.
Something that's a little lower tech, but maybe every bit as scary is I'm sure you've read about the use of Stingray devices, and that's a brand name. Generally, what that is a device that emulates a cell phone tower and allows the police to basically cause cell phones in a certain area to hook onto that device rather than to the normal cell tower. They can manipulate the cell phones, do things like certainly determine their location, but run the battery down, cause them to ring, obtain
shut them off,
metadata, that sort of thing.
Right.
And those, the thing about those that was really upsetting is they were provided to local law enforcement through a contract with the FBI, and part of the contract was that the local law enforcement agency was to keep confidential that they were using them. So they would write their search warrants in such a way as to disguise that they had used these devices. There were instances where, one instance in particular that one of our panelists testified about is an agent was on the stand, the very good defense lawyer surmised through just looking at all the facts that one of these devices had been used, and asked the officer, was it used? And he said, I'm not going to answer that. And the judge said, why not? He says, because it's part of a confidentiality agreement with Department of Justice. And the judge said, well, you're going to answer. That agreement doesn't hold any water here. Took a recess, came back, and I don't remember if it was an outright dismissal on the case or a very favorable plea agreement that the defendant took. But in order to prevent revealing the details of the use of the device, the state basically caved in.
Okay. So we've got these Stingray devices, and exactly how does that affect the average person who might be just using their cell phone? You're saying that how does that work exactly? It looks like a cell tower, so that, let's say, a drug dealer or somebody that might be of interest to the government will they set up next to him, and then they run this, and so the cell phone signal goes through that Stingray device. Can they then hear what's being said on the phone?
Well, part of the problem is we don't know the capability of it because we haven't been able to get all the details on it.
Wow.
We think at a minimum what it could do is if they go into an area, it's not just the suspect's cell phone that hooks on. It's other people's cell phones as well, and we don't know what data could be collected. The main problem with it at this point is that there was this effort to disguise its use or to conceal its use, and there's very much an effort to prevent disclosure of the capabilities of it, and so we're not sure what's being collected from whom.
Well, now, what's the future of that, in your opinion, in terms of mass data collection? It just seems to be getting worse and worse, and there's a lot of people that say, "Oh, it's okay with me because it keeps us safe." Isn't there a big PR campaign to kind of say, "What have you got to fear?" It's all good. It's this whole anti-terrorism thing. If we take away this capability by law enforcement, then we'll all be a lot less safe. Isn't that where the government is headed with it? So that privacy concerns are basically become less important.
John Oliver did a piece on that not too long ago and questioned people on the street about how they felt about that, and they were just fine with collecting conversations from people overseas that maybe had some connection with terrorism, but when they explained to them that law enforcement also collects, and I don't know your audience, so I won't use exactly the words, but pictures of your genitals that you may have texted to your significant other or spouse. How do you feel about that? And of course, they were outraged about it. It really depends on whether your ox is in the ditch, I guess, on the particular data that's being collected.
Right.
And the point is that this technology allows collection of any type of data.
Right.
It can be indiscriminate, and on that particular subject, that gets us into another area of search of cell phones that the Supreme Court addressed this last session. What if you're arrested on something? You have your cell phone then is taken into custody. What can be searched?
Right.
What are the warrant requirements? Because cell phones are not just a device you call somebody on now. They're the device that you have a lot of data about your life on and access to the cloud for unlimited data that may be personal to you. So it's not just the electronic surveillance grabbing this stuff out of the air that we're concerned about, but data searches in general on seized items, hard drives and traditional searches, data on cell phones, etc. But back to what I was talking about, George, when I was sitting there listening to this, it dawned on me how little I knew about it. And so one thing that we were doing this year is we're putting together what I'm calling an advisory panel. We're inviting some of the people that were at the symposium, maybe some others, who are on the cutting edge of this stuff, who know what's going on, know what the technology is and how it's being used, to advise our practitioners on what they need to do to combat the use of this stuff in court. First of all, is to discover whether it's been used, and then to raise, by proper motion practice, the use of it and determine if there's been a constitutional violation.
Well, that's going to be, and I'm going to have to leave you right there. There's going to be an advisory panel on this. For those of you out there, we've been with Gerry Morris for the last hour, and we're going to have to say goodbye to Mr. Morris and thank him for being here. But there will be an advisory panel on this mass data collection. So that's just one more thing that the NACDL does. So, listen, if you want to get a hold of Gerry Morris, he's an attorney in Texas, and he's I found him on the internet today. So it's he's famous down there. He's one of the top lawyers in Austin. And it's been a pleasure to have the president of the National Association of Criminal Defense Lawyers here with us for the last hour. Thanks a lot, Gerry Morris.
Thank you for giving me the forum.
All right, great. And if you want to hear the whole show, thank you, Gerry Morris. And we're gonna leave you here, ladies and germs. But listen, what you need to do is go on to my website at ghylaw.com. You can listen to this whole show. You can also listen to my other shows on the Innocence Project, Eyewitness Testimony, Jury Verdicts, all that sort of stuff that we've talked about today. Please join us next week on Justice for All. I'm George Yates. We're here every Saturday from 2 to 3, and we will interview another legal expert next week on some interesting stuff in the world of the justice system in America. So bye now.